Well, that wasn't totally the case, but I didn't have understanding of what court I was in, and I didn't understand if it was a criminal jurisdiction, civil jurisdiction.
How are you going to represent yourself if you don't even know the elements of the offense?
I have to defend against the accusations, the charges. The people of the state of Michigan is trying to sue my corporation. That's correct, right? And you are acting as a trustee, correct? Y'all acting as judges and acting as trustees, correct?
Yes, sir.
Okay. So, Mr. Myrick, good morning. I've got this set for a pretrial. Now, I have a note here that said that you were not interested in court-appointed counsel, which is fine. So basically, at this point in time, it's a pretrial. So I would set you up with a breakout room with the prosecutor to see, what if they have any offers or what their story is. I just want to make sure when you go in there, like you don't have an attorney with you and they're the attorney on the other side. They may give you an offer that you like, and that's fine. But I just want to make sure that that at any point in time, if you don't like the way the conversation is heading, if you change your mind and you do want to come back and ask for an attorney, just come back and let me know. Okay.
Okay. Before I get into the breakout, Your Honor, I do want to address we are in the pretrial stage, and in the arraignment stage, I was entered a plea involuntarily. So I would love to have an ample amount of time to draw a meaningful defense. If anything, there was some questionable things that the last judge mentioned that I haven't found at all as far as a statutory jurisdiction. But I would like to have time to draw a meaningful defense as well.
Okay, so do you not want to meet with the prosecutor then?
Well, I don't think it's completely prudent right now, simply because we haven't technically went past the arraignment stage of this process. I feel as if my due process has been violated. Fifth and 14th Amendment. I didn't enter a plea, and here we are in pretrial. So I would like to kind of digress a little bit and have at least enough time to develop a meaningful defense.
Okay, I guess I'm a little confused. So you had an arraignment date, and
Yes.
At that arraignment date, did you refuse to enter? Did you refuse to enter a plea? Because that's the time where a plea of some sort has to be entered. So at that point in time, did you, of your own volition, say, I'm not saying anything at all?
Well, that wasn't totally the case, but I didn't have understanding of what court I was in, and I didn't understand if it was a criminal jurisdiction, civil jurisdiction, and based on the at least the federal laws for sure, we didn't come up to an understanding. So.
Okay, so were you in? So just so I understand, were you in custody at the time you were arraigned? Were you in custody?
No, sir.
Okay, so how did you know how to even zoom in and get here?
Say that again, Your Honor.
How did you know, like for the arraignment, like oftentimes when there's an arraignment, that happens when someone's been arrested and they're sitting in custody, okay, or if they've received a ticket or some sort of notification. So you just said to me that you didn't even know what court you were in. So I just want to know, like, how did you know how to get here? How did you know how to zoom in? Because the Zoom information contains all of our like what court it is, what magistrate, like all of that's contained in there. So I just how did you know otherwise?
No, I did receive a ticket, and I got notice. But what my issue was appearing here on special appearance today, and I needed to get understanding of what jurisdiction I was in.
Okay. All right. So because I definitely want to make sure that people know where they're supposed to be. So I think I'm looking at the same ticket that you had. So it says on the ticket, 44th District Court, Royal Oak, and then the court address is on there. And then you said that you received notice. So the notice that went out it would have had the Zoom instructions. Again, Mr. Myrick, as you can imagine, we are, I'm always very concerned in making sure people have the proper notification and all that. So it does appear that, I mean, you're here a second time. The only thing that I was, now looking at the file here, you were ordered to post a bond and you didn't. Now, I'm reading the notes here. It says there was a bond of 1,000 cash surety, no 10%. So $1,000 bond was expected to be paid within 48 hours. Now, Mr. Meyer, we're here today. You showed up on time. So one of the reasons that a bond is ordered is, one, for the safety of the community, and two, to a secure appearance. Well, you come here a second time, and so I am very comfortable that you are going to continue to show up. So I, at the very least, for you, Mr. Myrick, today, as long as you continue to abide by the expectation that you'll show up, and you have twice now, I'm going to actually amend that bond. So that even though you were supposed to do it within 40 hours and you didn't, okay, the fact that you showed up here again, at least to me, is enough evidence to suggest that I can count on your appearance going forward. So
that's righteous.
I'm going to amend the bond to a personal bond. Okay, remember, that's not a cash bond. It's just your personal promise that you'll continue to show up for court dates as you have so far. So
Yes, sir.
I'll amend this to a 1,000 personal due to defendant's multiple on-time appearances.
And what I'm ultimately asking, Your Honor, is that if I can have more time to, I don't have any discovery. I don't have what I need to assess to move forward. So if I can have more time.
I have no problem during the pretrial, so that you could do some more information gathering.
Yes,
just to let you know, Mr. Myrick, again, like our court, as you can imagine, with 696-75 Woodward, we have a lot of traffic misdemeanors that come through this court, and one of our signature programs that we've been doing for the last 8 years is, trying to really help people, because I would imagine that you pay attention to the challenges of the Metro Detroit area and public transportation issues and people's ability to get around, and how many people over time have got themselves in the cycle of they have to drive, but they pick up a ticket and they can't pay that ticket, so their license gets suspended and they get stuck in the cycle forever and ever and ever. Okay. Well, in our Operation Drive program, what we've done over the last 8 to 10 years, we've been keeping stats since March of 2016. So in the last 9 years, we're over 1,700 licenses restored. So that's something that we try to do, is make sure that we inform, educate, get people the information that they need, which, Mr. Myrick, you could probably imagine, for years and years, the court system hasn't been great about letting people know even where to start, how to get their license. So in the meantime, while you're doing your investigation, I at least want to let you know, bear with me. I'm just looking at what's on your record so that you can at least know, because some people don't even know where to start, how to go, or what to do. And the law has changed in a significant way. It used to be that every single little ticket that you get would suspend your license. Now it's only a couple tickets here and there that do that. So, okay, so.
I'm very honored, Your Honor, to be in your courtroom. I think you're the one that I've heard so much good news about, goodwill and good-hearted judge that assists the public, to opposed to the opposite. So I truly appreciate your efforts here. Thank you very much.
Well, you're welcome. So, all right. So, so just to give you a heads up, I mean, I would imagine that over the time, because I mean, to be fair, it's been a while since you had a license. Um, that there might be, like this idea that there's a ton of tickets that are holding you up. There's actually only two tickets. Only two tickets that are actually suspending your license. There's one no proof insurance from like 2005, and one from 2000, and that one's in Detroit. Okay. Now you might have a number of tickets in Detroit, but basically now you can be surgical in your approach. Instead of having to pay the whole boat, you can pick the one that is suspending your license.
Yes,
now
sir.
you'll have to ultimately pay them all, but as you know, Mr. Myrick, it's a lot easier to pay off tickets if you have a job that you can get to reliably without having to pay for Uber, Lyft, all that kind of stuff.
Yes, sir.
And so, or looking over your shoulder all the time, rolling the dice.
Yes, sir.
And so, what we try to do is let's get in there, make a surgical approach, take care of the tickets that are actually suspending you.
Yes, sir.
And then you can get about the business of taking care of the other ones, once you get your feet underneath,
Yes, sir.
So it's there's a 2005 no proof insurance out of Detroit and a 2009 out of Allen Park. Now, if those two are taken care of, all that's left is a 125 reinstatement fee with the Secretary of State.
Wow.
So you've got those two, all right. The 125 reinstatement, Secretary of State. Now, since you haven't had a license in a while, I'm not going to sugarcoat it. You're going to have to take the written and the road test again. But again, after all this time, after all this, energy and frustration with the process to have to sit down and take a written test, Mr. Myrick, obviously you are aware of your rights and you know how to study and do the work. You pass a written test, no problem. And then the road test, you could take that right away. So literally, Mr. Myrick, again, I'm going to give you whatever time you need, but you're actually probably closer than you've been in 20 years to getting a license. If, again, you decide if that's a priority for you. But again,
it is, Your Honor. It is. And it has been daunting. It has been daunting.
See, I get this, and I get the sense too that so much of the frustration with the process is in so many ways justified, because Mr. Myrick, that's what I was seeing for years. People were coming in, and basically the system turned individuals who are otherwise law-abiding, hardworking people just couldn't pay a ticket, and then made them feel like criminals, and they weren't. And so what we've been doing, and it's so funny, Ms. Chappelle's here. She's one of my Operation Drive attorneys. I mean, like, that's what we do. We get people back to work. We get people back to, not walking around in a virtual prison. So,
yes, sir. Thank you very much.
So, all right. So, let me see. One piece of advice that I can give you too is you can actually look up. There's not like some secret judge website. You can actually look up and see how much the ticket is. Can you, let me do this real quick. I'm going to send you a chat right now. Just tell me if this pops up on your end. Okay.
Okay.
It just say chat. Did that come up on your end?
I did. I do say notification. I'm going to click it right now.
Perfect. No, I mean, I
Yes,
just want to make sure you can see it. Okay. So
yes, sir.
If, let's see here. Okay, so so the 36th District Court, the only challenge I will say though is that because Ms. Chappelle, because his tickets are from his no proof insurance is from 2005, are those going to be harder to look up because they're outside it?
The criminal matters are the 7-year. I can probably still find the 2005.
Okay, because I just want to make sure. I'm going to look this up because I want to see if we can figure out how much that ticket actually is, so that before he leaves today, you know what the.
Do you mind if I grab a pen, Your Honor, so I can take record as you?
Yeah, go ahead.
Thank you.
Yeah, go ahead.
Judge, my client's in the waiting room. Miss Henry.
Okay. Perfect.
All right.
Okay. As soon as I finish with Mr. Myrick, we'll call that next. Okay.
I wasn't trying to jump ahead, Judge. I was just letting.
No, no, I'm glad. So I'm glad you brought that up because I see her there now, and I'll bring her in and we can get that going. Okay.
I don't want to get in the way of Mr. Pelly's excellent work today.
Okay, so Mr. Myrick, I'm going to share my screen. Okay, real quick, so you can see. All right. Okay, so can you see this? It should be like it says court case inquiry.
Yes, sir.
Okay. All right. So I'm just going to go back real quick. So I literally just Googled 36 district court case lookup. So again, anybody can do this. All right. And then it got to this screen that says look up case balance. And I clicked on accept view case balance. And then it gives me a register of actions. Okay. So
Yes,
I'm going to try, and I'm hopeful that we still will be able to pull up, at least find out what the balance is on this ticket. Okay, so I'm going to chat to you in just a second that ticket number. See my concern, Miss Chappelli. It's not pulling that up. So let me see if I can pull up the name. See, these are just to give you an idea, Mr. Myrick, this is some of the issues that we run into is because people try to track down things, and because of some age of the matters, things like that, it might not be immediately easy to discover. But I'm going to take a look just real quick at some of these outstanding tickets just to make sure. Let's take a look. Come on. Yeah, it says here. Oh, here we go. Yeah, so it only has anything. It looks like to me it doesn't have as old stuff easy to access. Was there a different spelling of your name ever, sir?
No, sir.
Okay. All right. So here's what I want. I'm going to give you. Okay. Remember when I sent you this chat? I'm going to send you the actual ticket number. All right.
Yes, sir.
My only frustration is I can't give you the dollar amount, but traditionally the no proof insurance, Mr. Chappelli, down at the 36, they usually been a max like 288, right?
It'll either be 288 or 336.
Okay, so there is. Did you get that chat from me right now? It should have come through.
I missed the notification. Can I?
No problem. I'll do it again.
Okay. Gotcha.
Okay. All right. So, and then I'm also going to send you the Allen Park ticket number. Okay. And I don't know, does Allen Park have a lookup, Ms. Chappelli, at all? Do you know?
Yeah, I do. I can try to look it up for him.
So, Your Honor, are these two ticket numbers that you sent me in the chat?
The first one, so the first one I gave you, I did it on repeat. Okay. That's the 2005 no proof insurance out of Detroit. So if you contact Detroit, give them that ticket number and say, or if you even want to show up there, just go walk in there and say, I'm here to pay this ticket. How much is it?
Yes, sir.
Okay. And then once you pay that ticket, then they send a clearance to the Secretary of State. Then that's one down. We got one to go. And now I'm going to send you the Oak Park, or the Allen Park ticket. And Ms. Chappelli, you'll be able to see this once I send this. I'll just send this in the general chat. If you're at the. Okay. Do you see that, Mr. Myrick?
Yes. Yes, sir. I do see it. I'm recording it right now. And this is the 2009, right?
Exactly, 2009 out of Allen Park.
And there is a lookup, Judge, but I'm not finding that ticket.
Okay, so yeah, so that's so it looks like that's the only ticket out of Allen Park. So you should be able to call up there, say, here's my ticket number. I'd like to pay this ticket. Okay.
Okay.
Now, from my familiarity, just so you know as well, like the Berkeley prosecutor, if someone is going to get engaged with our Operation Drive program, usually there's a reduction to a non-traffic misdemeanor, so it doesn't go on your record, doesn't extend it. And so, in addition to you looking into your own defenses and things like that, all the things you're doing will also put yourself in a better position to have a good resolution from the Berkeley prosecutor on this one, even if you decide, okay, well, I don't really have the defenses to this, but I definitely don't want to extend my suspension. I don't want any points to go on my record to push this out further. Okay. All right. But once those 2 tickets are done, then
I think I just found it, Judge.
Did you?
I think so. This 2009. Is that what we're dealing with from Allen?
2009. Yeah.
Okay. Sorry, the system's kind of slow today.
That's all right.
All right. So there is a drove by license, and this is the spelling of the name's accurate. It was an order of annulli pros regarding a drove by license suspended, but they still have a $45 fee showing. And then going back, there's 3 separate tickets. And then going back to the second ticket, because Judge, you're thinking it's an NPOI?
Yeah, it should be an NPOI.
All right. Because there are 3 tickets, all of which are showing 45s. So
really?
Yeah. So let me look at the second one. Sorry, it's taking so long.
That's all right. That'd be great news, because that'd be just $45.
No proof of insurance. This one was a default judgment. It is showing $45, but it is showing a bond that you posted, sir, back in 2009 of $398. I think they took that, so perhaps they applied it to that fee, and they just want the 45. That may be the answer on that one.
So okay. So best case scenario, they'll let you just pay the 45. Okay. Worst case scenario, they'll want the $45 on each of the old tickets. So 135. So best case scenario, 45, worst case scenario, 135, but that's Allen Park.
Wow. That's great.
And that's 24th District Court, sir, if you're looking it up.
24th District.
And it's interesting because these are very old cases, but the close date on the third ticket is 2017. And now I'm getting error readings. So, but there's just 3. Looks like you had your bond taken on the no proof because perhaps you didn't go back, and that may satisfy that.
All right. So Mr. Myrick, so here's what we're going to do. I'm going to bump this out a couple weeks. You get to work chopping away at that kind of stuff. But I will say this. I only want to bump it out a couple weeks because if you get those things done, all right, I want you to come back and see me. We'll be able to run a new driving record. We'll see if by doing that, all right, that they follow through and let the Secretary of State know. Because if they take your money and they don't let the Secretary of State know, then the suspensions remain. And then we can even contact the Secretary of State and just make sure that they know, like, oh, by the way, he paid those. Right. And then when you come back here, you can give me an update, but just know if you've paid those 2 tickets, you should be able to go into the Secretary of State and pay the reinstatement fee and go from there. So what do you think, a couple weeks?
Safely to say, I would say 30 days.
Fine.
If I can have the grace.
No problem. No problem.
Thank you, Honor. I appreciate you dearly, too. Thank you very much.
You're welcome. All right, so we'll adjourn this 4 weeks, and we'll send notice again. And then just do me a favor, Mr. Myrick, if you run into issues, I'm gonna send you our direct line here at the court.
Thank you very much, Honor.
And for example, if you do decide if you're running into issues, I certainly can connect with Mr. Angot, Ms. Chappelli there. Mr. Angot's our MIDC coordinator. I know that you initially were not inclined to go with assigned counsel, but what Mr. Pelly's doing today is exactly what would be done. So if you just reach out to us, let us know, like if you're running into brick walls and you say, like, I would like an attorney attached to this case, then call us and we'll get it done. So here's the number directly.
Yes, sir.
I just sent it to you. I could just give it to you. It's 248-246.
No, I'm in the chat, Your Honor. I see it. 248.
246-3651.
Yes, sir.
Okay, so I look forward to seeing what you can get done, Mr. Myrick. Again,
Yes, sir.
I could tell you are a person of conviction and that you are willing to do what it takes, but certainly have been very frustrated by the way in which the process has worked for the last 20 years. So let's see if we can change the narrative here, okay?
Yes, sir. Yes, sir. I really appreciate that. That makes my heart sing. Thank you.
Good luck to you, sir. We'll send you a note. See you in 4 weeks.
Thank you.
Take care.
You can call Ms. Tubbs' case.
Okay. Following case 2400390201. The people of the state of Michigan versus Tanea Nicole Tubbs. This matter is scheduled today for competency hearing. Appearances for the record, please.
Good morning, Your Honor. Elena Rozak on behalf of the people, P78815.
William Glenn, P36794 on behalf of Ms. Tubbs. Ma'am, state your name.
Beneficiary, Tanea Nicole Tubbs.
All right, Ms. Tubbs, you have a constitutional right to be physically present in the courtroom. Do you agree to waive that right and hold this hearing by Zoom?
I agree.
Okay, thank you. Counsel, I've received a report dated February 13th, 2025, authored by Andrew P. Sheff, licensed psychologist, consulting forensic examiner. Have you both had an opportunity to review that document?
Yes,
Yeah. Yes, Your Honor.
Do you both agree, stipulate to that being admitted as court's exhibit number 1?
Yes, Your Honor.
And that'll be marked and admitted as court's exhibit number 1. All right, and do you stipulate to its findings?
Yes, Your Honor.
Yes, Your Honor.
All right, then the court will find that it says opinion. It's my opinion that Ms. Tubbs is competent to stand trial.
Yes, Your Honor.
Okay, then it says at the last paragraph says, while I recognize the ultimate decision in this matter rests upon a judicial determination, it's my opinion that Ms. Tubbs was competent to stand trial at the time of this evaluation. You both stipulate to both of those findings?
Yes, Your Honor.
Yes, Your Honor.
Right, then the court will sign an order. Is she receiving medication? Is she?
She's in the Calhoun County Jail. I don't know yet.
Ms. Tubbs, are you receiving medication?
No, Your Honor.
No medication? All right.
No, ma'am.
And counsel, are either you aware that she's receiving medication?
I am not aware, Your Honor.
I am not aware, Your Honor.
I don't see any mention of medication here, so. All right, and I'm signing the order finding her competent to stand trial. And do we have a trial date on this matter?
March 17th.
What day?
March 17th.
Okay, so this matter is scheduled for March 17th at 9 o'clock. Has counsel had a chance to discuss whether this matter is going to be resolved or not?
Your Honor, I had filed a notice of insanity to get a criminal responsibility report. I have not received that yet. Once I get that, I'll have a good idea as to whether we're going to be able to settle this or whether or not we have to go to trial.
Your Honor, I object on that. I would like to exercise my Sixth Amendment right, and I would like to reserve my rights to not be compelled to perform under any contract or commercial agreement that I did not enter into knowingly, willingly, voluntarily, or intentionally. And I furthermore do not accept any liability of compelled benefit under any unrevealed contract of the commercial agreement. And that's under Code UCC 1-207. And I have the rights to represent myself and waive all counsels knowingly, willingly, and intelligently. And I would like to.
Right,
That's
so
for the
you're
record.
requesting that you be allowed to represent yourself? Is that what I'm hearing?
That's correct.
All right. Well, then I'm gonna voir dire you with regard to that decision. Would you like an opportunity to speak with your client in the breakout room with regard to this decision, counsel?
Well, she said that a couple of times, but I would ask that the court hold off on that till I get the criminal responsibility. So, once I get that, then if she wants to represent herself, then we can.
Well, ma'am, do you want to do are you saying you're not going to do the criminal responsibility evaluation?
I do not need to do any of that, sir.
I'm sorry,
That's defamation of character. I will not be doing any of that. And I would like to
You do
exercise.
not want, you are requesting that you not do a criminal responsibility evaluation. Is that my understanding, ma'am?
That is your understanding. Correct.
Well, yeah, with the MIDC's policy, I don't know if I can continue as her attorney of record. She has to have standby counsel appointed if she's going to represent herself. That's my understanding of their current policy.
All right, and you do standby counsel?
No, yeah.
All right, well, would you like to talk with her before she makes this decision? I'd like to have you speak with her.
Yes, Your Honor.
So, ma'am, I'm gonna have the attorney go into a breakout room with you and just talk to you. This is a very important decision. I'm not saying I'm not gonna do it, but I just want you to talk with him and understand some of the risks of doing this. And, okay?
Your Honor, I understand all the risk and I do not wish to talk to him. I have not talked to him in 6 months, so why would I need to talk to him now? Thank you. I pray you respect my wishes.
So just so I'm clear, you're refusing to talk with him, is that correct?
Correct. I understand all the consequences and repercussions in this case.
Okay, all right. Then let's, ma'am, we're gonna need you to have you sworn in for you to self-represent yourself, okay? I want to ask you some questions, just so you understand. Can you swear her in, please?
Ms. Tubbs, please raise your right hand in front of the camera where we can see it.
I do not swear in, but I wish to tell the truth and nothing but the truth.
All right, then will you affirm?
I
can
am
affirm.
here to, I'm here
All right,
to reserve
let's
my
have you
right.
raise your hand and you can affirm, okay?
Do you solemnly swear to?
No, do you solemnly affirm?
Do you solemnly affirm to tell the truth and nothing but the truth, so help you?
I tell the truth and nothing but the truth.
Okay, you have to put your right hand up, ma'am, please. Let's do it again.
That's against my religion, sir.
All right, then ma'am, I'm not gonna have you self-represent you until you do this. So if you're not gonna do it, we're gonna continue the attorney with you. All right? So you tell me what you want to do, Ms. Tubbs. Because until I go through these questions with you under oath, we're not signing any, we're not
But I need to
having
know
you
what
present
oath,
yourself.
what oath am I going under, sir? I have the right to know what oath I'm going under because I don't go just under any oath.
All right, well, let's have her raise her hand again and you say the oath, the affirmation. It's not an oath, it's an affirmation. Raise your right hand, please, ma'am.
Do you affirm?
No, yeah, okay.
Do you affirm to tell the truth and nothing but the truth, so help you?
I tell the truth and nothing but the truth, and I come in as beneficiary of firm.
All right, thank you, ma'am. What's your name?
I am the beneficiary, Tanea Nicole Tubbs.
All right. Do you understand that you have a right to have a lawyer represent you in this case?
Yes, sir.
Do you understand that I will appoint a lawyer to represent you if you cannot afford a lawyer?
I waive that right.
Huh?
Well, I understand what you're saying, but I waive that right.
Okay. Do you want to have a lawyer represent you?
No, sir.
Can you afford a lawyer?
Yes, sir.
Okay. What is the maximum sentence in this matter, Madam Prosecutor?
In this matter, Your Honor, it is
punishable up to 5 years or a
It's-
fine not.
Ma'am, just wait, let me speak, okay?
I'm
Madam
sorry.
it would be 7.5 years because the defendant, it's carrying concealed weapon, which is a 5-year maximum penalty, but there is a habitual second offense notice, so that would increase the penalty to 1.5 times the maximum sentence, which would put it at 7.5 years.
All right, ma'am, the maximum possible sentence in this matter is 7.5 years because you are a habitual offender second offense notice. So it's 7.5 years is the maximum sentence. Would you like to talk with a lawyer, with a court-appointed lawyer to decide if you want to represent yourself or not?
No, I would like to represent myself and put in the motion to dismiss.
Okay, so ma'am, first of all, can you give me your educational background?
I
How
have
far have you gone in school, ma'am?
college.
College, okay. And have you represented yourself before?
Yes,
And why do you wish to how many times have you represented yourself?
twice.
Okay, and then what, were those in criminal matters?
One is, yeah,
And what happened with that case?
I got it dismissed.
Okay. And what was the other case you represented yourself, Ms. Tubbs?
I'm actually doing that now. It's for another criminal case, actually.
And you're representing yourself in that case?
Yes.
And why do you wish to represent yourself in this case?
I wish to represent myself in this case because I have learned all the trade secret acts, and I'm fairly fed up with how this courtroom is operating and suing people without letting them know that they are entering into a contract with you all as owning our vessels, and I'm tired of it. I'm tired of it. No one owns me.
All right, ma'am, tell me what the elements of this offense are.
The elements of this offense is that it's punishable by imprisonment for more than
No, that's not what the
Oh.
the elements of the offense are.
the elements. What do you mean
Yeah.
by elements? Because y'all
Well,
use double
that's the problem. You
Y'all
don't
use
know.
double language here, so I know.
How are you going to represent yourself if you don't even know the elements of the offense? How are you going to do that, ma'am, if you don't even know what you have to defend against?
I have to defend against the accusations, the charges.
All right, ma'am, tell me what the rules of, do you know the rules of procedure?
The rules and procedures to this is
Yeah.
that a prosecutor, the people of the state of Michigan is trying to sue my corporation. That's correct, right? And you are acting as a trustee, correct? Y'all acting as judges and acting as trustees, correct?
No, I'm elected as a judge. I'm not a trustee. I'm a judge, okay? Ma'am,
Okay, so what?
ma'am,
so
no,
what-
you don't get to quiz me. Ma'am, what, do you know what the rules of evidence are?
Yes.
Okay, tell me what the exceptions to the hearsay rule are.
Acceptance of the hearsay. Hold on, I want to write all this down.
I'm sorry. No, I'm asking you. You say you know this stuff. How are you going to represent yourself?
You got
don't even know what.
acceptance of hearsay, sir. I would like to write everything you're saying down so I can
Have
be
you
able
ever
to.
have you ever done jury selections or jury instructions?
Yes, jury, it holds up to 12 people.
No, do you know how to ask them questions?
Yes.
And how to do the jury instructions? All right. Do you know how to preserve issues for appeal?
Yes,
Do you know that self-representation is almost always unwise?
yes,
Did you know that the first day of law school, they tell us that he who represents himself has a fool for a client? Do you know they tell us that?
yes.
And so what does that tell you if they say he who represents himself has a fool for a client? What's that tell you, ma'am?
You know what it tells me?
Yeah,
That
what's
you
that tell
are-
you?
You all operate in trade secret acts. So
Okay.
you
Well,
will be a
that's not true, but okay. Miss Tubbs, would you do brain surgery on yourself?
Why would I do brain surgery on myself?
Yeah, because you'd have a fool for a patient, wouldn't you?
Correct.
So why do you think you can do law if you can't do medicine?
Because I go by federal law.
Okay. You understand you'll receive no special treatment and you can receive no help from the judge during the trial. You understand that?
I understand.
You understand the prosecutor is an experienced trial lawyer who is unlikely to give the defendant any special consideration. Do you understand that?
Yes,
You understand you'll receive no special help from the court staff and you'll be expected to follow the same requirements that apply to practicing lawyers. You understand that?
yes,
Madam Prosecutor, have I complied with MCR 6.005?
Yes, Your Honor.
All right, ma'am, do you believe that your waiver of an attorney is knowingly, intelligently, and voluntarily made
correct.
and accurately and understandably?
Yes,
Then the court will find that the waiver is knowingly, intelligently, voluntarily made. The waiver is unequivocal. You understand the disadvantages of self-representation, and self-representation will not disrupt, unduly inconvenience, or burden the court. So I'm going to grant your request.
The law allows someone to represent themselves, but that doesn't mean it's strategically wise. Overconfidence can make a person mistake confidence for preparation. Once the court confirms the decision is voluntary, the responsibility shifts almost entirely onto the defendant, and legal mistakes become much harder to undo.
Best to represent yourself, ma'am, okay?
thank you.
All right. Now we've got a jury trial. What's our date?
And I would like the full discovery package sent to me, please, as well with along with the Dr. Chef report.
Can you
And the
get her
oath of
whatever
office,
discovery
please,
you
so I
have?
can know what I'm dealing with.
All right.
Do you guys
You'll
just go
send-
by maritime law or common law?
Ma'am, it's not maritime law. You need to learn the law, okay? I'm
Well,
not,
I
I'm
know-
not advising you on the law. I told you, I'm not advising you. If you don't know what it is, that's up to you to find out. I'm not advising you on anything on the law, ma'am.
Don't worry about it. I know what it is.
Yep, don't ask for any special consideration. You have to perform just as any licensed attorney would here. So if you don't know that, I would strongly recommend you have an attorney represent you. If you don't even know if it's a maritime law or not.
It's my right to ask questions.
All right,
'Cause
well,
you-
go ahead. As I said, he who represents himself, he or she is a fool for a client, ma'am. Okay, we will have the attorney send you those documents. Madam Clerk, if you can get a standby counsel for this for March 17th at 9 o'clock. Is there anything else we need to take up?
So am I here released?
Yes, you're released.
Thank you, Your Honor.
Your Honor,
But you need to send all the materials to her. And
Your Honor-
also, if we can get her brought here from the jail, Madam Clerk. Okay,
that's what I was going to ask for, is to have her written here and then another date before the trial date where standby and Ms. Tubbs would be here. Where we would all be on the same page.
well, we're gonna get the standby and do that right away, as soon as we get that.
Okay,
I
We can
request that,
schedule this for, ma'am, don't interrupt me. I don't interrupt you, you don't interrupt. All
excuse
right,
me.
we'll schedule this for February 19th at 9 o'clock for assignment of a standby counsel, okay? And if you can make sure that she is on Zoom that day, Madam Clerk? Okay, is there anything else we need to take up with regard to Ms. Tubbs' case? And you, ma'am, just so it's clear, you're under oath, you are requesting that there not be an insanity defense, is that correct?
That's correct. And I also,
Okay.
February 19th,
Madam
I
Clerk,
have
if you can
something
prepare,
scheduled at 9.
ma'am, don't interrupt me. Prepare an order that says that she's withdrawing any insanity defense. Okay, all right, what, Ms. Tubbs?
I have another court time at 9 a.m. on February 19th.
All right, then we'll make this February 20th at 9 o'clock, all right?
Thank you.
These two hearings reveal something important about how courts respond to unusual legal arguments. Neither judge tried to win an argument. Instead, each focused on creating a clear record that the defendant understood the choices available and the consequences that followed. In the first case, the discussion gradually shifted away from jurisdiction questions and toward practical solutions. The judge identified obstacles that could actually be removed, explained how old license suspensions could be resolved, and left the defendant with information that could improve his legal position regardless of how the underlying case ended. That approach reduced conflict without changing the legal standards that still applied. The second case moved in the opposite direction. The defendant relied on familiar sovereign citizen ideas, like the UCC, contracts, beneficiary, commercial agreement, and maritime law. But the hearing wasn't about deciding whether those theories were correct. It was about determining whether the defendant knowingly accepted the risks of self-representation. Once the court established that understanding on the record, the responsibility for every future strategic decision shifted to the defendant. That distinction matters. Courts generally protect a person's right to make difficult legal choices, but they are not required to protect someone from the consequences of those choices. Rights and strategy are different things. A person can legally choose a path that significantly increases legal risk. Across both hearings, the strongest lesson isn't about sovereign citizen arguments at all. It's about how small procedural decisions, accepting help, rejecting counsel, gathering evidence, or insisting on going alone, can shape the entire direction of a criminal case long before any verdict is ever reached. Sometimes the outcome begins changing long before the trial itself.